The Honorable Court of Criminal Appeals of the State of Tennessee is now in session.
Good morning. This is the March session of the Court of Criminal Appeals in Nashville. The panel this morning is Judge Robert Montgomery from Kingsport, Judge Kelly Thomas from Maryville, and I am Norma McGee Ogle, and I'm from Sevierville. Each side will have 20 minutes for argument. If you would like time for rebuttal, please let me know how much time you would like before you begin your arguments. We are ready for the clerk to call this case.
State of Tennessee versus Christopher Scott Montella.
Good morning. Mr. Turner?
Okay, my name is Jonathan Turner. I represent Mr. Christopher Montella, and I'd like to reserve 5 minutes for rebuttal, please.
I will note that.
Thank you, Your Honor. And I'm just going to go over some brief procedural history, then the facts, and then I'm going to go and expound on point number 5 and point number 3. Basically, we're on appeal from the Marshall County Circuit Court for Mr. Montella being convicted of aggravated sexual abuse back in 2019 in October. He was tried by a jury and found guilty. He was also found not guilty of another offense of showing sexual material to a child under the age of 13. Later on, in October 2019, he was sentenced by the trial judge to serve 11 years in prison. And that's the procedural history that he later noted his appeal after he did a motion for a new trial. The facts are not overly complicated. Basically, Mr. Montella met the alleged victim at church in Marshall County. It was with the consent of the family, and the family basically wanted him to be a mentor for this young man. And he would, based on the family's parental agreement, he would take him to various activities, take him to the pool, take him to Sky Zone, and a bunch of other activities. And on occasion, he would have him stay at his house. And all this was with the permission of the parents. He never did anything secretly or without them knowing. Later on, in 2018, after the alleged victim spent the night at his house, Mr. Montella was confronted by the police and arrested, and he was accused of aggravated sexual battery. At the time, the alleged victim accused Mr. Montella of grabbing his penis while he was at Mr. Montella's house, staying over for the night. Interesting, the alleged victim gave a forensic interview shortly thereafter, and then later he testified at a preliminary hearing. And between those two different dates, he changed his story for several details. One, he changed the time of the event. He changed whether he had a phone. He changed the story about whether the circumstances about the night before, about Mr. Montella pulling his pants down. And later on, as of note, right before trial, he then changed his story and said that Mr. Montella grabbed him in the bed while he was sleeping over it in the bed with him. And also of note, the alleged victim changed his story. He accused Mr. Montella of kicking him, and then he accused him of choking. Based on all that, Mr. Montella, of course, was tried on these cases. And this gives us to point number 5, that a mistrial should have been granted in this case due to juror misconduct. And what happened was, during voir dire, the trial judge asked the jury panel, the panel of jurors, did they know Patrick Taylor, Miranda Taylor, and Demerit Taylor, which was the father, the mother, and the alleged victim. And undisputed on the trial transcript, the trial judge said, after he asked the question, he said, "All right, no hands." So And then after that, no one spoke up. That is undisputed. If you look at the video of what happened, the video is very unclear, but it does show that all the parties are facing outward towards the juror, and no one really, there's no indication that anyone raised their hand or even answered affirmatively. Later on, the mother testified, and no one spoke up that they knew her either. Well, after Mr. Montella was found guilty, a couple of weeks later, it came to light that one of the jurors, Dakin Pullum, had actually been Facebook friends with the family, that he had actually said, "I love you" to the mother on Facebook, that he asked to be called Uncle D on Facebook when there was a new child in of the family. He wished the father happy birthday. He was Facebook friends with the alleged victim's sisters. So he used to be he was an in-law to the mother, but then there was a death in the family, and that relationship wasn't, there was no more step relationship, but he did have a relationship with the family. So based on that, a motion for new trial was filed, and the trial judge denied the motion. And during that, he accredited Dakin Pullum. Dakin Pullum took the stand, and the trial judge accredited whatever Dakin Pullum said as being truthful. And Dakin Pullum said that during voir dire, when the question was asked about the father, the mother, and the alleged victim, that he did in fact raise his hand, and that he did suspect that he knew the father, but he didn't recognize the mother's name. Now, after that, it's undisputed that after the judge said, "All right, no hands," he did not speak up. He just remained silent. Then Dakin Pullum testified that during the trial, when the mother took the stand, he realized that he knew her and that he did not speak up, and he just decided on his own that he was able to ascertain that he didn't have any bias towards them, and that therefore he could just sit and be a juror. It's our position that a presumption of bias arose when he sat in silent over the question about whether he knew the father. By his own testimony, even if you credit his testimony to being truthful, it is undisputed that he remained silent during the time when the judge said, "All right, no jurors." He didn't answer and say, "Wait a minute, I did raise my hand." If he thought it was important to raise his hand when he thought that he knew the father, why didn't he speak up and say, "Listen, I'm raising my hand, no one's seen it," and acknowledge that? But instead, he just remained silent. And it's our position that because he remained silent, the law is clear. If a reasonable answer in voir dire would give rise to an answer, that he should have gone ahead and said, "Listen, I think I know the father," and then we would have been able to voir dire him. But instead, he just remained silent. And then when the mother testified, he obviously knew that he had a relationship with her, but he just decided on his own halfway through the trial that he wasn't even going to say anything about it. And it's our position, because he did this, that the presumption of bias was never overcome during the motion for mistrial, that obviously Dakin Pullum had a bias because he actually had a relationship with his family. Someone who says that they want to be an uncle of the victim's family shows that this is more than a casual relationship, as the state tries to assert. So based on that, we would ask that Mr. Montella be given a new trial based on the juror misconduct. Then I'll go to the next point that I want to expound on, is the Brady violation, that the state failed to provide Brady information that gave rise to a Brady violation and violated his right to a fair trial. In that, basically what happened, we were in day 2 of the trial, and during that time it came to light that the alleged victim had changed dramatically the circumstances of the alleged incident. Before, he had alleged that Mr. Montella had gotten in bed with him at various times and then grabbed him. Well, at trial on day 2, he changed his story to saying that Mr. Montella was actually sleeping with them that night. And that's a dramatic change in the story. Brady is clear that if there's exculpatory information that's not provided by the state and is prejudicial, that it's a Brady violation. And here, the information is obviously exculpatory because his testimony comes into question and he's changed his story. And we would submit that there's no dispute that it's exculpatory. And 2, the state did not disclose it prior to the trial. In fact, it was on day 2. So we had already done voir dire. The opening statements had already been done and 2 witnesses had already testified, one being the mother. So because the state slow played the information that they knew that the child had changed the testimony the week before trial, within that week, that the appellant was unable to use the information during voir dire, was unable to mention that the alleged victim changed his story basically the week before, a year after the incident, more than a year after the incident. And 3, when the mother testified, and she was testifying about the circumstances surrounding the alleged victim, talking to her about what happened, we were unable to bring out the fact that, isn't it true that he changed his story a week before? And I think based on all that, the impact towards the jury verdict was greatly impacted because it comes into play when information is being withheld. The state alleges, well, the appellant was able to cross-examine him, but the problem was we were on day 2, 2 witnesses had testified, voir dire had been done, opening statements had been done, the damage had been done. The state is basically asking for a policy to be set by this court, and they cite no case law that's controlling, that slowly giving exculpatory evidence during the middle of a trial and allowing it to be brought out on cross-examination cures the fact that they didn't give it before trial and allowed the appellant a chance to actually investigate and deal with the information.
So the state withheld the information for 1 week. Is that what you say the record shows?
It was within the week of the trial, a few days before.
What does that mean?
That means that the state knew that the alleged victim had changed his story from not sleeping in the same bed as the appellant to actually sleeping the night with the alleged victim.
And how many days did they know that they didn't tell you?
I think it's like 2 or 3 days before trial.
Okay. Did they give any, when this was being dealt with and addressed on the record, did they give any reasons for that delay, why they didn't immediately disclose it?
I believe the reason that they gave, Your Honor, was basically the DA was saying that he didn't intentionally do it and he thought it was a minor detail, and he thought that it would come out anyway during trial.
Well, yeah, I guess it would. All right, thank you.
Yes, Your Honor. So it's our position that by not disclosing this Brady material, that it did violate my client's right to a fair trial, and a mistrial should have been granted, and that the judge abused his discretion in that. And that's our main point on the Brady violation. I would like to highlight that
you have about 2 minutes before you get into your rebuttal time.
Thank you, Your Honor. I'm just going to be real quick on the insufficiency of the evidence, because I think this is a symptom of what has really happened with the juror infecting the jury panel. The fact is that during the trial, there was no physical evidence to back the claims of the alleged victim. And we would submit that the evidence was insufficient because of the several changes of the alleged victim's testimony, the time, of the circumstances, whether he was hit, choked, whether he slept with them, that there was way too many changes in the testimony to have a reasonable juror rely that it was actually, that he should have been found guilty of aggravated sexual battery. And it's clear on the record, the alleged victim said that he was not truthful during the forensic interview, was not truthful during the preliminary hearing, and actually recalled the events differently over time. And we would submit based on that, his testimony was too incredible to actually be believed by a jury. And with that, I'll just reserve the rest of my time for rebuttal. Thank you.
Thank you, Mr. Turner. Mr. Finley?
Good morning, Your Honors. May it please the court. David Finley on behalf of the state. I'll take these in reverse order. As to sufficiency, this was a credibility contest. And as the court knows, the jury, that's their prerogative to determine credibility. Even inconsistent statements can nevertheless support a verdict. And in this case, we have a young victim who is remembering things as he goes along. And he's changing his story somewhat, but the gist of his story remains the same. So we submit that on sufficiency, the evidence is more than sufficient to support that. As to the Brady issue, Judge Thomas, regarding your question on who knew what and when, it does appear that the state knew several days in advance. Apparently it was on a Friday. When this issue came up though at court, the defendant specifically stated something on the record that he did not think there was any intentional act, did not ascribe any intentional act to the state. But his complaint was that he'd already made his opening statement. So the record is not really developed on why the state withheld it or what happened, the exact timeline here. The defendant apparently didn't really have a beef with the state. Disclosure was simply upset that was not able to use it during an opening statement. The state pointed out, and then we pointed out in our brief, that the defendant's entire theory, indeed, as the defendant's argued now, is that the victim was not credible. And this simply is another brick in that argument that the victim was not credible. So this is not so much a Brady issue as a delayed disclosure issue. The defendant certainly had time to utilize this in his cross-examination and in closing argument. And indeed, it was his entire theory of the case in his opening statement. So, Your Honor, we would submit that the defendant was not prevented from utilizing this in his defense. And at best, this delayed disclosure, and the defendant was able to use it. As to the juror issue, the trial court accredited Mr. Pullen's testimony on this issue. And I think it's worth noting that Mr. Pullen testified that he did in fact raise his hand when the court asked if anybody knew Patrick Taylor. He said he knew about 4 Patrick Taylors. He didn't know which one the court was referring to, so he did raise his hand. And I think as reflected in the record, several other people raised their hand when they were asked the same sort of question about various people. And the court basically looked at everybody that had raised their hand and said, well, despite this knowledge, can you fairly sit on this case? And everybody agreed they could. So this is where Mr. Pullen later on, when the victim's mother took the stand and he realized, oh, I know her. This is where he realized, well, okay, the court has already asked if we can fairly hear it despite knowing them. And he knew her from a billboard. He recognized her from a billboard, but having any physical contact, there's nothing in this record indicates any physical contact between the parties other than Facebook messages. And these messages are 4 to 5 years old.
And you said there had never been any physical interaction ever or?
Ever. It's not reflected in the record, Your Honor. What we have here are a series of Facebook post exchanges between about 2011, 2014, 2015. Notably, Mr. Pullen was connected to the victim's family distantly by marriage with his uncle, but when his uncle died, that disappeared, but that was around 2017. Notably, there are no exchange of Facebook messages at the time the uncle died, which you would think if there was a close relationship, there would be some sort of exchange of messages. So there's nothing there. There's no evidence that gifts were ever exchanged on birthdays or anything of that nature. Mr. Pullen testified that while the victim's family may have come to the funeral home for his uncle's funeral, he did not remember seeing them. And there's just simply no proof other than these Facebook exchanges in the record, which are 4 or 5 years old. And the trial court essentially held that at best, there was a casual relationship at the time of the Facebook exchanges, but certainly by the time of trial, whatever relationship existed 4 or 5 years earlier was tenuous at best. And the record supports that finding, Your Honor. This is very much like the furlough case, I think, which we have cited. There was at best a extremely casual relationship some years earlier. At the time of trial, no relationship whatsoever. So we submit the trial court properly found there was no reason, no presumption of bias, and properly denied the motion for mistrial.
Thank you, Mr. Finley.
Thank you. We ask you to affirm.
Mr. Turner, you have your rebuttal time. There's a problem with the audio for Mr. Turner.
I apologize, Your Honor. I had the mute on.
Thank you.
I'm sorry. Thank you for letting me know. I'm going to go to the juror issue. As far as the state has mischaracterized what actually happened during voir dire, there was 2 different exchanges. The first exchange was the trial judge specifically asked, did any juror know, potential juror know Patrick Taylor, Miranda Taylor, and Demary Taylor, the father, the mother, and the victim? And the record is clear. It says, all right, no hands. So right there, the Dakin Pullen testified that he raised his hand, but he testified that he remained silent about that. So the second question was the trial judge listed all the witnesses, and that's where a bunch of other people raised his hand. So no one is acknowledged by the court to raising their hands about knowing the family. And that's a completely different question than knowing any of the witnesses. And the fact of the matter is the state's alleging that this is just a casual relationship, that there's no real relationship. However, the question was, did you know them? Obviously, Dakin Pullen thought that he knew them because he's saying he raised his hand, but he remained silent about that. By remaining silent, he acquiesced to the fact that no one saw him, that he knew the family. He should have, by raising his hand, he should have said something. When he said something, then we would have been able to voir dire about what kind of knowledge he had about the alleged victim's family.
Were these group posts?
No, these were personal messages to the person. So when it says like, I love you, this was directly to the mother, Miranda Taylor. When he said, I want to be called Uncle D, this was a direct message to the mother. When he said, happy birthday, it was a direct message to Patrick Taylor, the father. When he had several comments directly to the family. And he was Facebook friends with the sisters of the alleged victim. The state's alleging that, well, no one testified that he had Facebook posts and all this other evidence. The problem, Your Honor, is just because the evidence wasn't presented doesn't mean it doesn't exist. The inference is there was a relationship. It's a fair inference, and it's fair to assume that there was some other contact because they were at the same funeral. Dakin Pullen agreed that they were at his uncle's funeral, and the mother of Dakin Pullen testified that he knew the children of the alleged victim's parents, despite Dakin Pullen taking the stand and claiming that he did not know the children. So we would submit that based on the record, that there was enough information where Dakin Pullen should have spoken up and admitted that he knew the family, and that by not doing that, is presumed to be prejudicial, and Mr. Montella was not afforded a fair and impartial jury and should be given a new trial based on As far as the Brady violation, the state is arguing that it's not a Brady violation. There's no dispute that within a week, the state had the knowledge that the alleged victim changed his testimony, and that the information was not given until middle of the trial. The state is alleging, well, the only prejudicial effect is that it wasn't included in an opening statement. Well, it's also prejudicial in the fact that voir dire, Mr. Montella wasn't able to voir dire any of the jurors about alleged victim changing a major circumstance of the story a week before trial. And third, the mother testified at trial, and the appellant was denied the right to cross-examine the information that the state remained silent about. The state did not give any of that information before the mother even testified. And therefore, withholding that information was prejudice towards the appellant. And the policy of this court should not be that the state should be allowed to withhold exculpatory evidence until the middle of a trial, and then allow trial counsel to scramble to try and be able to do what they can with the evidence at that point in time, and depriving any other fairness before trial. And based on that, we would ask that a motion for mistrial or retrial be given to Mr. Montella based on those arguments. Thanks. That's all I have.
Thank you, counsel, for your very good arguments this morning. And that concludes this case. We will be in recess.
This court is now in recess.
Thank you, Your Honor.